Hello and welcome to Williams Mullen Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Ed White, and today I'll be joined by my colleague, Janet Cho, a partner in our intellectual property practice group here at Williams Mullen, to discuss Made in the USA, the connotation and its meaning to your brand. How are you doing today, Janet?
I'm doing well, Ed. How are you?
Very good, very good. Well, I have to say I'm very excited about the opportunity to discuss this today. I think that a lot of people, a lot of consumers in the US right now are very focused on the supply chain. Not surprisingly, in the post-pandemic era, they're looking at how the supply chain has affected them just in their everyday consuming. They're concerned about how things are being manufactured overseas, which delays the supply chain into the US. And they're looking now to try to bring, and as our businesses, some of that manufacturing back to the US in various industries, everything from pharmaceutical ingredients to consumer goods. So I'm really excited to hear what you have to say today about what it means when someone puts Made in the USA on their brands and what the connotation is to their brand for consumers. So with that, let's jump right in. Can you give us a little bit of background?
Oh, absolutely. And I like this topic as well because it's a topic that initially when I first thought about it, it seemed as though it was relatively straightforward. There wasn't much to really investigate or interrogate. It's something is either made in the USA or MUSA, as I'll call for short during this podcast, or it isn't. But MUSA claims are actually fairly complicated, and the analysis of whether or not something is made in the United States it's very nuanced, and there's a lot to think about, and it's something that you shouldn't assert without thinking about it and having done some diligence. So with that, I wanted to provide some background on who exactly reviews these kinds of claims and what's at stake. So in the United States, the Federal Trade Commission, or the FTC, is the government agency that oversees false advertising claims, deceptive advertising claims, and included with that are potentially false MUSA claims. And they have a history of enforcing these claims, but recently, last year in 2021, they finalized a new rule that will really allow them to pursue, or maybe I can say crack down on marketers that are making false and unqualified claims that their products are made in the USA when they in fact aren't. There are no new obligations on businesses, but really the new rule codifies what the FTC has been doing up until this point. And there are two important things that come out of the new rule. One is that it allows those who've been injured by false claims to seek redress, damages, and penalties and other relief from those who have essentially lied about MUSA claims. And the FTC also can seek civil penalties of up to $43,280 per violation. So this is not just a slap on the wrist, potentially. There are some real financial and other things that are at stake. And I do want to emphasize that making false claims can severely harm your brand. It can turn consumers away from your products and from the goodwill that you may have developed in the minds of consumers. So it's really, really important to be careful and be mindful of how and when you're making your MUSA claims. Certainly because you don't want to run afoul of rules, but you also want to maintain the integrity of your brand, for sure.
Those are important points, and that change with the FTC's regulations is something that all, frankly, our clients should be thinking about as they make these claims in the future. What should people and entities know specifically about this?
Well, if there's one thing that people remember, or listeners remember from this podcast, I will say it's important to remember the phrase all or virtually all. And it's important because that's really the standard around the made in the USA claim. So I'll unpack that a little bit. But before I get started on the all or virtually all standard, one important thing to know, because this is what I was thinking when I was first looking into this, is, well, if I'm going to make a claim, I'll just go to the FTC and see if they'll approve my claim. But the FTC does not pre-approve claims. So there's no going for some advanced diligence with the FTC. It's really more of a prospective thing that a manufacturer needs to consider going forward in terms of their advertising claims regarding MUSA. So with that, what made in the USA really means, what it's intended to convey, is that your product is of domestic origin, and made in the USA should be made without qualification or limits on the claim. And made in the USA means all or virtually all of your product is made in the United States. So I want to unpack that a little bit, because all of those words seem as though they're easily understood, but they actually have some nuanced meaning. So when we say the US, we mean all 50 states, the District of Columbia, and the United States' territories and possessions. So it's a bit of a broader scope than just the 50 states, but it's not too much more. So I think that that's probably something that most people perhaps already understand. But I think it's important as a starting point to define the geographic scope of what we mean by the US and MUSA claims. And all or virtually all, in terms of the products that are involved, what that means is that all of the significant parts of a product and the processing that goes into the product must be of US origin. Another way to say that is that the product should not contain any, or it should contain negligible foreign content. And you have to be able to substantiate that MUSA claim. So when you say something is all or virtually all made in the US under the MUSA banner, you have to have a reasonable basis to say that. And what does that mean? It means that a manufacturer has to have competent and reliable evidence to back up the claim. So one thing I want to emphasize is that MUSA claims should not be made without thought or diligence. And you should be in a position, if someone were to ask you, well, tell me a little bit more, or tell me why, where this is made, or tell me more about the origin of the product, you need to be able to substantiate what your background information is about the product. And there are actually a host of factors that the FTC will look at when they analyze an MUSA claim in detail. They look at things like whether a product's final assembly or processing takes place in the US, because the expectation is that if something is claimed to be made in the USA, the product's final assembly or processing takes place in the United States. And they also look at other factors, such as how much of the product's total manufacturing costs can be assigned to the United States, parts originating in the United States, or processing that takes place in the United States. And similarly, or perhaps this is the flip side of that, is how far removed are any foreign parts from the finished product? So in other words, if there are foreign parts in the finished product, how salient are they to the operation of the product, or to how the product works? So you can see that MUSA really is something that is not as straightforward as one might think. But again, you want to remember the all or virtually all standard. And just to restate this, because I think it's really, really important, as you said, during COVID times, there's been this renewed emphasis on made in the USA as a claim, and products that are made in the USA. You want to make sure that all or virtually all your products are made here, and that you have a reasonable basis to make that claim, and that you're not simply making some presumptions or taking information passed to you. And along those lines, if you're a manufacturer that is reliant upon suppliers to create your product, if you are essentially trying to rely on supplier representations, you can do that, especially if your supplier representations are given in good faith. You can rely to some extent on that, but ultimately, you would be wise to investigate your supplier claims before you just wholeheartedly rely on supplier representation. So again, I think the best practice here in MUSA claims is to make sure that you've done your diligence as a manufacturer or as a marketer of products that may bear the MUSA label, and make sure that you've gone back and checked to make sure that this representation is accurate and you've done all that you can to get to the bottom of whether or not your product truly has an origin in the United States.
Yeah, thank you, Janet. That's great detail for our listeners, especially those listeners who are in the manufacturing field and want to be able to make that claim made in the USA. As a consumer myself, one other thing that I'm starting to see on packaging is the wording assembled in the USA. And, at first blush, you'd say, well, that implies the same thing as made in the USA. But I suspect it's probably more nuanced than that, and perhaps it's different. Can you explain to us what assembled in the USA means when you see that on packaging?
Yes, the most important distinction between MUSA or made in the USA claims and assembled in the USA claims are that with assembled in the USA claims are products that do in fact have foreign components. For MUSA claims, you may be talking about products that don't actually have products of foreign origin. It may be that everything has an origin in the United States, but assembled in the USA, we're taking as a starting point that you do in fact have foreign components in your product. And to be able to say that something is assembled in the United States without qualification is when, and there's two parts to this, when the principal assembly of the product takes place in the United States and the assembly is substantial. So again, breaking that down, an easier way to say that is the last transformation of the product should have taken place in the United States. And an example of that is, let's say you have a lawnmower that is put together or assembled here in the United States, and all of the lawnmower's parts are domestic parts, except perhaps 15 to 20%. If the assembly of the lawnmower takes place in the United States with the majority of the parts being parts of made in the United States, then an AUSA or assembled in the USA claim is appropriate. The flip side of that is perhaps you have a computer and all of the major components of the computer are imported, but the parts are put together in the United States with a simple, what we call a screwdriver operation, meaning everything's just lightly put together in a very simple fashion. That is considered not a substantial transformation. And so this computer must be marked as being a product of having a foreign origin. Now, I realize those are very, very simple, general examples. We could sort of dig into those and ask further questions. But the one takeaway I want to say for assembled in the USA claims is that there has to be a last transformation here in the US, and the assembly has to be substantial. So for both MUSA claims and assembled in the USA claims, I think that there are certain buzzwords or perhaps guiding principles that manufacturers should think about as they go forward in trying to make these claims. But again, I would say the most important thing is to make sure you do your diligence so that you do in fact have a reasonable basis to make these claims in your advertising.
That's very helpful, Janet. And I suspect we're going to continue to see the increase of made in the USA or assembled in the USA claims on product packaging going forward. So this has been great guidance that you provided today. Well, that will wrap up our discussion on using made in the USA as part of your branding. I'd like to thank Janet for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as our past episodes of this podcast and our legal alerts. And be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.